Somalia boundary and argued that any proposed delimitation method should be guided by principles of equity, and that, I quote, in jointly establishing this maritime boundary, the two states are at liberty to opt for a delimitation methodology that guarantees equitable solution, end of quote. None of this is consistent with the position that Kenya now advocates before this court. Kenya's claim that the parties had somehow delimited their maritime boundary through a process of unilateral assertion and acquiescence many years before 2014 is fatally contradicted by the description of the 2014 negotiations contained in Kenya's response to Judge Crawford's question during the preliminary objections phase of this case. In that response, Kenya stated, and I quote, "It should also be noted that at the first meeting in 2014, the parties considered several options and methods for equitable delimitation, including bisector, perpendicular, median, and parallel of latitude as potential maritime boundaries, and that these methods were considered in regard to all maritime areas in dispute," end of quote. Kenya added, and I quote once more, "There was no commitment or expectation that negotiations would result in an agreed boundary for all maritime areas at once. Given the complex circumstances prevailing between the parties, it was entirely possible that agreements, whether conceived as temporary or permanent components of the boundary regime between Kenya and Somalia, may have initially covered one or more maritime areas, such as the territorial sea or waters within, say, 50 nautical miles off the coast, and with one or more purposes before the conclusion of a comprehensive final agreement. There was and is no pressing need to settle the entire maritime boundary immediately." The contents of this response to Judge Crawford's questions fatally belie Kenya's claim that the parties had already delimited their maritime boundary along a parallel of latitude, and all that remained in 2014 was for them to formalize that delimitation or that act of acquiescence in a written agreement. Were Kenya's claims to be true, then it is inconceivable that the bilateral negotiations in 2014 would have discussed a range of very different potential delimitation options for establishing potential maritime boundaries between the parties. And if Kenya were right that by 2014 the parties had somehow conclusively delimited or agreed their maritime boundary, then it would make no sense at all for Kenya to state that as of that date, there was no expectation that negotiations would result in an agreed boundary for all maritime areas at once. Nor would it make any sense for Kenya to refer to the possibility of the parties making temporary agreements in respect of some but not all of the maritime areas. Kenya's repeated statements to the judges of this court, to the CLCS, to Somalia itself, that no delimitation had occurred simply cannot be reconciled with the argument that it now puts to you, nor can its own domestic laws. What I have in mind is, for example, Section 4, Paragraph 4 of Kenya's 1989 Maritime Zones Act, for example, which is still in force today and which is referenced in numerous other provisions of Kenyan legislation and which has been officially notified to the UN Division for Ocean Affairs and the Law of the Sea. Let's take a look at what Section 4, Paragraph 4 actually says. And I quote, "The northern boundary of the exclusive economic zone with Somalia shall be delimited by notice in the Gazette by the Minister pursuant to an agreement between Kenya and Somalia on the basis of international law." End of quote. No notice of delimitation has been published in the Gazette or anywhere else. What's more, the language of Section 4.4 of the 1989 Act contrasts markedly with the equivalent provision in section 4.3 regarding the maritime boundary with Tanzania, which makes express reference to an existing boundary on an easterly latitude. There can be no doubt that Kenya regards section 4 of its own legislation as an authoritative description of the status of its EEZ boundary with Somalia. Why? Because that legislation was expressly quoted in Kenya's 2009 submission to the CLCS. Kenya has made no attempt to disclaim the existence or validity of that law. Similarly, Kenya's claim that the maritime boundary follows a parallel line in the territorial sea is expressly contradicted by its own Territorial Waters Act of 1972 and the 1989 Act. Section 2 of the 1972 Act provides that the parties' territorial sea boundary, and I quote, shall extend to a median line every point of which is equidistant from the nearest points on the baselines from which the breadth of the territorial sea of each of the respective states is measured, end of quote. And likewise, Section 3 of the 1989 Act in Kenya provides, and I quote, on the coastline adjacent to neighbouring states, the breadth of the territorial waters shall extend to every point of which is equidistant from the nearest points on the baselines from which the breadth of the territorial waters of each of respective states is measured, end of quote. These provisions of Kenya's own legislation further undermine Kenya's case on acquiescence. How can Somalia have acquiesced in a maritime boundary consistently asserted by Kenya along a parallel of latitude when Kenya's own national laws speak against the existence of such a boundary? You may well ask yourself that question. A governmental forum convened by the Kenyan National Assembly in October 2014 provides a truly revealing insight into Kenya's actual belief about the location and status of the maritime boundary. According to the official report published by the National Assembly, the director of Kenya's International Boundaries Office, who was actually a member of Kenya's delegation to this court during the hearing of Kenya's preliminary objections, delivered a presentation which was entitled Kenya's International Boundaries, Legal Challenges, Issues. Just like Kenya's position during the bilateral negotiations with Somalia, the director in his presentation made no reference to the existence of a maritime boundary established through acquiescence. On the contrary, the director explained that, and I quote, to date, Kenya's maritime space had not yet been finalized because of claims of it overlapping Somalia's maritime zone, end of quote. She proceeded to inform the meeting of the need to urgently complete the process of defining Kenya's boundaries. That was October 2014, which is just 2 months after the application in this case had been filed with the court. So it's abundantly clear that Kenya's senior public officials, including those responsible for legal issues on international boundaries, do not believe that a maritime boundary with Somalia had been established through acquiescence. Somalia does not suggest, of course, that the subjective views and beliefs of Kenyan officials are capable of affecting the status of the maritime boundary. But those views do, however, cast light on the credibility of Kenya's argument on acquiescence. The absence of any reference, even en passant, to acquiescence during a multi-day governmental forum on Kenya's maritime boundaries, held less than 2 months after Somalia initiated these proceedings, is, we say, highly revealing of the realities of the situation. The absence of any delimitation of the parties' maritime boundary is confirmed by others, including the views of other states and of international organizations. I may just give you a couple of examples. In April 2011, the United Nations Security Council issued a resolution which, and I quote, emphasized the importance of the earliest possible delimitation of Somalia's maritime space in accordance with the convention, end of quote. And then, in July 2013, the United Nations Monitoring Group highlighted the conflict between Somalia and Kenya on, as they put it, the need to negotiate a mutually acceptable maritime boundary. International organizations have also acted in a manner that confirms the absence of an agreed or acquiesced maritime boundary along the line of parallel. The African Union mission in Somalia has established a maritime zone of intervention off the coast of Somalia, which is, we say, virtually indistinguishable from an equidistance line. Madam President, members of the Court, this brief summary of the evidence makes it clear beyond any argument that the maritime boundary has not been delimited, and it has not been delimited by acquiescence, and Kenya is well aware that this is the situation. So I turn now to Kenya's claims regarding its alleged effectivité in the disputed area. You've heard already from Professor Pele why Kenya's reliance on those alleged effectivité is wrong as a matter of law. Let me now explain to you why it's also wrong as a matter of fact. In respect of naval patrols, Kenya's counter-memorial places much reliance on a supposedly secret map purportedly issued by Kenya in the 1980s. There is no suggestion or evidence that Kenya ever communicated any such secret map to Somalia. In its new evidence, filed just 10 days ago, Kenya seeks to rely on a memorandum supposedly circulated within the Kenyan Navy in 2004. Again, there is no suggestion that this document was ever communicated to Somalia. Nor is there any documentary evidence of the Kenyan Navy undertaking any patrols up to the parallel line in the decade between the 1975 proclamation and the enactment of the Maritime Zones Act in 1989. Instead, Kenya cites logs that purportedly describe the activities of a small handful of Kenyan vessels in 1990 and 1991. What's notable is that those logs do not purport to identify the location of any maritime boundary. Even if they did, it's not in dispute that in the early 1990s, Somalia was ravaged by a civil war and effective government had all but collapsed. Somalia had no ability to monitor or control its maritime space. And that's a point that Kenya itself has stressed in its written and oral pleadings in this case, and to which I shall return shortly. Incursions that Somalia was powerless to detect or prevent provide no support for Kenya's case. Kenya then relies on diagrams, which we were surprised to see it has recently updated in its new evidence. These are said to show the locations of 22 alleged interceptions of merchant vessels by the Kenyan Navy in a 24-year period between 1990 and 2014, together with the alleged locations of certain naval patrols between 2008 and 2015. This provides no support for Kenya's case. As the map on your screen shows, of the 22 alleged interceptions, you can see from the dots, only 4 occurred in the disputed maritime area. 2 of those 4 interceptions allegedly occurred in the early 1990s, when Somalia had no effective government, and the other 2 allegedly occurred between 2008 and 2011, by which time the maritime dispute had already arisen. A further 2 interceptions occurred north of the parallel line now claimed by Kenya, indicating that the Kenyan Navy undertook interceptions without regard to the existence of any maritime boundary. Second, the significant majority of the points plotted on the diagrams produced by Kenya merely purport to show the transient locations of Kenyan naval vessels in the disputed maritime space after the maritime dispute had arisen. There is, moreover, no suggestion whatsoever that any of those vessels were doing anything other than exercising internationally recognized rights of freedom of navigation and innocent passage, and such activities, as each of you well know, cannot constitute effectivité. Third, from at least 2012 onwards, patrols and interceptions by the Kenyan Navy occurred under the auspices of the African Union mission to Somalia, pursuant to the authorization of the UN Security Council, which of course was expressly premised on full respect for Somalia's sovereignty. Naval patrols pursuant to that multinational peacekeeping mandate cannot, on any view, amount to an exercise of sovereign authority by Kenya in the disputed maritime area. Kenya recognizes the total paucity of its evidence, and last week Kenya made an 11th hour attempt to bolster its case. What did it do? It wheeled out a witness statement from the former Chief of General Staff of the Kenyan military, a gentleman who retired about 16 years ago, and who somehow claims to be able to recollect the precise location of Kenyan naval patrols as far back as 1972. That is nearly 50 years. This gentleman, who seems to possess an extraordinary memory, his name is retired General Kibwana, makes no pretense at neutrality. Read his statement carefully, for he expressly advocates for a parallel maritime boundary. His evidence is partisan, it is untested, it is uncorroborated, and it has been produced about a week before the hearings in this litigation. It has no authority, and no weight could be fairly attached to it. Kenya also relies on purported evidence concerning marine scientific research and fisheries activities in the disputed area. Again, that evidence provides no support for Kenya's case. First, the majority of the activities were undertaken by international organizations, not by Kenya, a point Kenya doesn't dispute. Second, with just one exception, Kenya doesn't allege that any of those activities occurred within the disputed area. Activities outside the disputed area plainly are not relevant to the status of the disputed area. Third, Kenya does not claim to have authorized any of those activities. And fourth, even if Kenya had undertaken or authorized such activities within the disputed area, Article 241 of UNCLOS expressly provides that such activities, and I quote, shall not constitute the legal basis for any claim to any part of the marine environment or its resources, end of quote. And fifth, as Somalia explained in its reply, the specific reports and diagrams cited by Kenya are either ambiguous or do not purport to record the location of the alleged maritime boundary at all. The fallacy of Kenya's factual case, regarding its alleged effectivity is perhaps most clearly illustrated by its oil concession practice. Kenya is totally silent on the fact that the evidence makes clear that for more than 2 decades after the 1979 presidential proclamation, Kenya granted oil concession blocks that consistently respected an equidistance line. This is demonstrated by the maps